from, there you go, recordings in progress. I love that message. Okay, so as I was saying, we've got Alex, Friston and Hanna Frost from Shoosmiths. Shoosmiths are great friends of Midshires for as long as I've been at Midshires, which is some time. Every year they kindly give this presentation, so we do welcome them back, and we thank them so much for their continued support. It is greatly appreciated. And for those of you that don't know, Hanna is qualified as a solicitor in 2018 in the business crime and compliance team at Shoosmiths. She regularly advises companies, directors and individuals on regulatory compliance across a range of sectors, including health and safety, food safety, product safety and fire safety. And Alex is an associate in the firm's business crime and compliance team, and he also regularly advises on a range of clients across all sectors, including health and safety, environmental compliance, food and product safety. So welcome, Hanna, and Alex, thank you again for your time. And without further ado, it's over to you. Thank you.
Thank you very much, Roger.
Thank
I'll
you.
just share our presentation quickly so you can all see it, hopefully. Yeah, good evening, everybody. It's lovely to see you all. Is that okay on the presentation? Looking good?
Looks good.
Great. Okay, thanks for the thumbs up. Yeah, it's lovely to be here. Thank you so much for having us again. So I'm Hanna, and Alex, as Roger kindly introduced us, and we're both solicitors in the health and safety team at Shoosmiths, doing a range of work, but focusing a lot on health and safety. So hopefully we'll be able to provide you with some good insights today. So we're going to do a run through of kind of the legal update, talking through the most recent HSE statistics, looking at some key legislative developments, hopefully some interesting case law, and looking ahead to trends for 2022 and beyond. So Alex is going to start us off, and I'm going to hand over to him now just to run us through some statistics from the HSE and what they might mean.
Brilliant, thanks Hanna. Hi everyone. Yeah, as you can see there, and thanks Roger for the introduction. My name's Alex Friston, and yeah, I work for Shoosmiths as an associate, qualified as a solicitor back in 2020. So my experience from a health and safety perspective is very much got a sort of COVID background, I suppose you could say. So yeah, very new into it and really enjoying it so far. And away we go then. So again, apologise though if there is anything here where it appears that we are teaching you to suck eggs, but we just thought we'd take it nice and basic, go through some nice statistics, see where we're at pre-pandemic and sort of, I don't want to say post-pandemic, but further down the line, I suppose you could say, and see where we're at. So HSE obviously is the general UK regulator for health and safety. It's an independent body. To the extent that any information on compliance is required, we recommend as legal advisors that you should always consult HSE or the local authority as the first point of call. Just a sort of quick background then of how health and safety is dealt with from a legal point of view. The UK tends not really to have a body of administrative law and regulation. So instead we acknowledge both sort of civil and criminal law from a health and safety perspective. All regulatory obligations, I suppose you could say, are managed and enforced by way of criminal law. But there's kind of a hybrid for civil law too, when you're sort of dealing with who and what might be sort of insured against. Health and safety, again, from a legal perspective, is all about how companies in general are held to standards of what is reasonably practical or to standards of due diligence. It's for companies themselves, businesses, as opposed to prosecutors, to establish that they have effectively conducted their business as such to these standards, these high standards, we hope, to ensure that they can hopefully, or sometimes often not, avail themselves of a defence. So just a few statistics. It's been a while since we've provided an update on statistics. It's quite interesting to see what the differences are between 2020 pre-pandemic and now. So at the moment, as you can see from the screen, and these statistics are as of January of this year, I believe, there's 1.6 million people suffering from a work-related illness. Interestingly, this is 0.1, so 100,000 increase on last year. Interesting, definitely, to consider this fact, given the overwhelming amount of people that have been working from home over the last couple of years. But I suppose the one to note from that is that, you know, there's a number of sort of workplace and occupational health concerns definitely go beyond the physical. So there's, you know, a greater prevalence these days on mental health, work-related illness, as well as your standards, cuts and bruises, and so on and so forth. Note, interestingly though, that none of these deaths relate to those that have arisen from occupational exposure to disease, and that would include COVID-19. Just on that sort of mental health sort of statistic there, I suppose, work-related stress, depression, anxiety levels, these have all increased, non-surprisingly, to a rate higher than pre-COVID levels, so back in 2018 to 19, and that's up by 800,000 workers. And working days lost, interestingly, has increased by about 10.6 million. So it's, you know, significant figures here. Annual workplace fatality figures have shown a decrease over the last year. It had previously gone from 113, it shot up to 142 between March 2020 and 2021. And in the last year, it's gone back down to 111. RIDDORs, so reporting dangerous occurrences at the workplace, have reduced by about 3,000. Interesting one, does this necessarily mean that less injuries and dangerous occurrences have occurred? Absolutely not. Does it potentially mean that businesses have maybe become a little bit more slapdash over the last 2 years? Potentially. We do, as lawyers, tend to see a lot of businesses shirk responsibility from a health and safety perspective. Absolutely important not to, because ultimately it can lead to unlimited fine for the company and potential custodial sentences for any culpable directors involved. Most common causes of fatal injuries at work are, non-surprisingly, workers who fall from height, being struck by a moving vehicle, and then being struck by a moving object or two as well. These three instances effectively account for over half of all workplace fatalities. And then the overall cost of injuries to workplaces has increased by £1.2 million. Next slide, please. So just a bit about enforcement statistics. So just a brief, I know this is supposed to be a legal update. So corporate offences in relation to health and safety are, as discussed very briefly earlier, punished by way of fines. So in most cases, these are unlimited. And a lot of people always ask us, well, what does unlimited really mean? It's such a vague term. And effectively it is a fine imposed without a financial limit. So previously, health and safety offences were set between a limit of £5,000 and £20,000. And since 2015, there's been some sentencing guidelines that have been in place, which the courts have imposed, which effectively allows judges to consider various levels of the offence. So how serious the offence is, the turnover of the business, the profitability, degrees and culpability of harm. So there's lots of different factors, and we see now that a lot of fines are often entering the sort of the millions of pounds. Perfect example, which I've seen and which was very heavily publicised last year, was it was not strictly a health and safety prosecution, but Southern Water, so it's an environmental offence, were prosecuted and fined £90 million for some widespread sewerage pollution. So will this set a precedent moving forward? It remains to be seen, but effectively, you know, it does make clients a lot more, well, a lot less risk averse, I suppose you could say. Next slide, please. And just a quick update on the business plan. HC business plan for this year effectively covers, following Grenfell, a little bit about the building safety regulator, which Hanna will cover later in relation to the building safety bill. HSE is also going to be delivering the first year operational plan for the new GB chemicals regimes, as the independent GB regulator. So since the 1st of January last year, so post Brexit, the UK REACH, which stands for Registration, Evaluation, Authorization and Restriction of Chemicals, a new framework is effectively in place. And it's going to be quite interesting to see the government's potential plans moving forward, how that's separated from the EU's REACH plan. I think there's been a lot of backlash to this, to be honest with you, because bit of a plan from the government to sort of water down sort of regulatory requirements on some key chemicals. Substances of very high concern might not be, companies might not be as obliged as they were previously to sort of submit information, and I think it's going to be more on a voluntary basis now, but that sort of remains to be seen at the moment. And as you can see there's a 10-point plan for a green industrial revolution, which we will come on to later. Next slide, please. I think just moving forward again with the business plan, HSE has secured an additional £14 million in funding this year. This will be utilised to continue and increase the amount of spot checks, and definitely to review alternative models and solutions in the workplace. As it says there, they did continue to carry out spot checks and inspections during the sort of the bulk pandemic period, when we were in the lockdowns. Mainly to ensure that businesses were COVID secure. And Hanna, I know we had a number of clients that came through to us that were a bit worried about being checked about that, about social distancing, and because a lot of the time the rules were so vague and so on and so forth. But the most important, I think, thing moving forward from a business plan perspective is that the HSE now have said that they would like to complete any sort of fatal investigations that come through. They'd like to complete 80% of them, 80% of the investigations within 12 months of them coming through, and then 90% of non-fatal investigations within 12 months of the incident. So that's sort of a moving forward point for the HSE. Thank you.
Okay, so just moving on to key developments for 2021 and 2022. So starting with, we've mentioned it already, but it's kind of the pervasive and unavoidable topic at the moment of COVID-19. So as you'll all know, very recently, the government's lifted a lot of the restrictions, and we're now in the living with COVID phase. So it's a lot more focused on personal responsibility, and a lot of the restrictions from the government have been we've been released from them. But it's important to remember that from an employer's perspective, the health and safety obligations to employees and the public haven't changed. The health and safety legislation still requires employers and business owners to do everything reasonably practicable to provide a safe working place and a public place of business for the public as well. So you may consider that it's safest to maintain some of those policies and procedures that you've had in place to tackle COVID in your businesses, rather than respond with a knee-jerk reaction to the new living with COVID guidance. So it's just something to think about, and especially on that final point on the slide there, thinking about home working and hybrid working, which is definitely here to stay across the board for lots of different industries. And it's about keeping alive to those risks and the new risks of the changing workplace. So thinking about whether workers can work safely from home, like what type of work are they doing at home, and controlling any risks associated with DSE. And then also, as Alex mentioned as well, that increase in stress and mental health for workers as well, and making sure that that's managed as much as it can be. So then just moving to the COVID-19 public inquiry, there's been quite a lot in the news about this lately. So it's been announced, it hasn't started yet, but the chair of the inquiry has been announced as Dame Heather Hallett, who brings with her a wealth of experience to the role. Her appointment's been welcomed across the board as someone that does have a lot of experience in this area, and she led the inquest into the London 7/7 bombing, and she's worked on the Iraq fatalities investigation. So her appointment has been welcomed, and we were all waiting with bated breath for the terms of reference for the inquiry, because that's what's going to give us an indication into how robust an examination of the government's actions the inquiry really will be. And they were released on the 11th of March 2022 and are now subject to a public consultation, but which actually ends today at 11:59. So if you are looking to have your voice heard, then there is still time. But yeah, a few hours left of that. So the terms of reference that have been published in draft are extremely wide. They have two main aims. The first is to establish a factual narrative account of the government's response to the pandemic, and that it covers everything from the response in healthcare settings to the response in prison and school settings to the response from an economic perspective. So it really does cover every possible kind of angle from that perspective. So that's, you know, extremely wide, and I mean, likely that hearing the evidence from the inquiry and from all the interested parties is probably likely to take a long time. And then the second main aim that's stated in the terms of reference is to identify the lessons learned. So this is obviously with a view to informing the UK's preparedness for any future pandemics, and also looking at how the lessons learned from what we've experienced in the last few years can be applied to maybe other civil emergencies that might arise. So it's about kind of making those improvements and incorporating those lessons learned. So yeah, the public consultation closes tonight, then it'll kind of take all the points of the consultation on, and the final terms of reference will be published kind of in due course. We don't have an exact date for them, but we know that the inquiry chair has said that once the draft terms are agreed, which should be relatively soon, they'll start collecting evidence, which will be for the rest of this year, and then hoping to start the public hearings in 2023. So once the draft terms are approved, we expect things to move quite quickly. So those that are looking to be involved or expecting to be involved will need to be able to respond quite quickly. So early preparation and kind of early consideration of what might be relevant to your business is key there. Just handing over to Alex now for the Grenfell update.
Brilliant. I mean, since the Grenfell Tower tragedy occurred back in 2017, I mean, right now there's not really a great deal to update you on, but I suppose the most pertinent point really is the fact that as a result of the fire, there's already been substantial changes that have come into force to building safety as a whole, arising mainly out of phase one, as you can see on the screen there. Perfect example being the creation of the building safety regulator, and then there's the Fire Safety Act, which has come into play of April last year as well, which I will cover next. The inquiry effectively has split. We're now in phase two, which, as it says on the screen, currently underway. Currently is splitting this evidence into modules, focusing on topics such as big one, which is cladding, obviously, role of firefighters, complaints, communication with residents, so on and so forth. At the moment, we're hearing evidence on the role of the central government in lead up to the fire, and then following that, it will consider the aftermath of the fire. So what happened with any of the bereaved, survivors, residents, and then the ultimate impact on them to this day. Next slide, please. So just another recent key development, which is very pertinent, is the Fire Safety Act. Effectively became law in April of last year, and overall it amends the Regulatory Reform Fire Safety Order, so the FSO. It's introduced, as I said, following the Grenfell Tower tragedy, and its overall purpose effectively is to clarify who or whom is responsible for managing and reducing fire risks in different parts of multi-occupied residential buildings, and with the overall aim to prevent any future tragedies from occurring again. Next slide, please. So yeah, effectively the Act makes amendments to the FSO, the main purpose being to improve fire safety, and specifically in buildings where there are effectively 2 or more domestic premises within, so number of flats and so on and so forth. And what it's also done is sort of set out a clarification for the accountable individual, and any duty holders, building owners. These guys must effectively manage the risk of fire for the following parts of the building. So the structure, the internal walls of the building, cladding, balconies, windows, common parts, and front doors too. Under Article 3 as well of the FSO, the responsible person of a premises, effectively the one who has control of the premises, is widened as well, and it may now include building owners, leaseholders, and managers too. Next slide, please. So building owners will now be held accountable for not complying with the necessary fire safety guidelines, which are set out by the Fire and Safety Rescue authorities. Even though the Act effectively now provides better clarification on sort of fire safety responsibilities, interestingly enough, it doesn't seem to mention who is to bear the cost of any sort of historical or future remediation works to a premises for the purposes of fire safety compliance. So there is a little bit of a worry that leaseholders potentially could now face footing the bill for sort of any expensive remediation works, including the removal of unsafe cladding. There is no doubt also that the Act will probably bring further issues, so for insurance companies, and definitely in relation to who is the responsible person and who is the individuals or who are the individuals that are qualified to carry out fire risk assessments. Next slide, please. Originally published. Sorry, I just got one more. Apologies.
Oh, you got one more point on your fire safety. Sorry.
No, that's it. Thank you.
Okay.
Cheers.
Yeah. So just picking up on the building safety bill then. So the building safety bill, you've probably seen it publicised a lot in the news. Again, it's as Alex mentioned, coming out of the Grenfell Tower inquiry, the first report, a lot of changes. I mean, the biggest overhaul of building safety, I think that we've seen for a really long time, and really changing the whole procedure. And it's going to be quite the overhaul for those that are caught by the legislation. And in that sense, that anyone that is affected by the legislation, the new legislation, is advised to get ahead, even though it won't actually be coming into force until probably about 2023. It's actually just had its third reading in the House of Lords. It's a real fast-moving bill. It's changing all the time. So it's just had its third reading in the House of Lords, and then it's been kind of awaiting being made final. So it's been a long process, kind of originally published in 2020, but reaching those final stages now. So it's extremely wide in scope, like the kind of last slide said, but one of the most massive overhauls of building safety that we've seen for decades. It'll apply to those higher risk buildings, kind of taking that, the lessons learned from the Grenfell Tower tragedy and looking at multi-occupancy residential buildings over 18 metres, including student accommodation, but currently not those other kind of accommodations listed on the slide. And it will just introduce across the board, I mean, lots of different things that I'll run through now and try and summarise for you, but yeah, generally a more stringent safety regime across the board for buildings. So one of the main changes that the bill has brought with it is the introduction of a building safety regulator, which will sit within the HSE, and so that's completely kind of created from scratch as its own new regulator, and they're kind of on the slide listing some of their powers and what they will have to do. So they'll be looking at kind of setting up multiple committees, including a residents panel, and as you'll see with the other updates that I talk about with the building safety bill, engagement with residents of buildings is at the heart of a lot of the changes that are brought in by this bill. Again, learning lessons from some of the areas for improvement identified as part of the Grenfell Tower inquiry. They will have enforcement powers. They will be able to enforce under the bill. That will be their role. They'll be looking to do a cost recovery approach as well. So it'll be interesting to see how that's dealt with that first before they've kind of got their work underway. And just facilitating building safety and keeping the safety standard for new buildings and all buildings just continuously under review, and making sure that things are safe and that the new rules are being adhered to. So that's the building safety regulator. And next, one of the other big changes is the gateway regime. So they're splitting the life of a building into 3 stages with different duty holders at each stage of the building's kind of life cycle. And this is to make sure that at each stage of a building's life cycle, safety is at the core of what's being discussed. Safety is kind of signed off at each stage, and that there's this new principle that's been brought in called the golden thread, which is about keeping all the safety information in relation to the building, in particular kind of the fire safety stuff, held centrally and easily accessible, so that if there is a problem, the information that fire services need about the building can be found really, really easily. And that was, again, another lesson learned from the Grenfell Tower tragedy, where it was quite difficult in the aftermath of the fire to get the key information about the building that was needed. So this golden thread should hopefully serve to improve that situation and make sure that safety information is readily available. So just looking at the gateways in a little bit more detail. So gateway 1 is the planning stage, where a fire statement is needed to be produced, and that can be submitted to the local planning authority as part of these initial discussions about the building. So that needs to be considered at an early stage and signed off and incorporated into the overall planning proposal, and the building safety regulator will be consulted on that. Then Gateway 2 kind of will be more similar and bolster the existing building control system. So it will provide a hard stop where construction is not able to begin until the regulator is satisfied that the building is compliant, or the plans for the building are compliant with the building regulations, safety and fire safety. And then the final gateway is about kind of that before occupation phase, where all prescribed documents must be handed over to the accountable person for the building. They must be submitted under the golden thread to be held centrally. And kind of occupation can't happen until everything like that has been submitted and approved. So those are the 3 gateways. Then, as I've just mentioned them. So they create, the Building Safety Bill creates a new duty holder, which is the accountable person for the building. And they have a number of roles. It's quite an onerous duty on the accountable person, and it'll be interesting to see kind of the type of people that take on these roles, and kind of what training that they get, because it is a completely new role. A lot of the training, I suppose, will need to be started from scratch. I have seen some training kind of popping up, and maybe there's kind of like almost a mini industry that will pop up around that, helping to train accountable people to make sure that they can comply with what is a particularly onerous set of responsibilities. So again, they're just listed on the slide. Again, you can see one there about residents engagement strategy, assessing the building safety risks and making sure that the safety case for the building is complied with and created in the first place, and then also kind of making sure that the golden thread's maintained. So those are the developments. The last one actually on there saying to appoint a building safety manager is something that's been scrapped under the latest round of review by the government, or by Parliament, the House of Lords. They have taken away the kind of building safety manager role and rolled it into the accountable person role. So the accountable person will now be responsible for the day-to-day running of the building, communicating with residents and providing any information as needed to the building safety regulator. So it just shows how this bill is a real moving piece. There's been a lot of amendments as we've come through, and the reasoning behind that amendment, from what I've seen, is that it's just more efficient for it to be one person. But again, for that person who it does end up being, it will be quite an onerous duty. So it'll be interesting to see how that plays out for people. And then just kind of finally just summarising some of the other key developments arising out of the building safety bill. So there will be more protection for leaseholders, and this is something that we've seen in the amendments phase, particularly from the House of Lords, that they've been doing kind of when they've been looking at the bill, is that they've been putting more of the onus to protect kind of more of the onus on developers to protect leaseholders. So the building owner will have more responsibility to try everything that they can to fix any problems with the building before they look at charging the leaseholder and spreading the costs among the leaseholders. So that is a positive step for, as you will have seen in the news, like a lot of leaseholders that are facing kind of lots of high charges for stuff like defective cladding and things like that. The legal liability time period has been increased quite considerably from 6 to 15 years. So for claiming against a developer for a defective building, you can claim now for up to 15 years, or when the bill becomes an act. So that's interesting again, because kind of if you have a new building, maybe the defects in the building wouldn't come to light till quite a few years later. So having that extra time can really probably help a lot of leaseholders, because I guess the developer could have moved on by the time that the problems come to light. Then looking at the new homes ombudsman, a massive industry, obviously, new homes builders kind of working to create new homes all around the country, and there will be a new kind of ombudsman to deal with any complaints and to enforce a new code for residential properties. So that's again another kind of regulator type body created as a result of the bill. And then another one for the construction products regulator, which will sit within the Office of Product and Safety Standards. And so their goal is to monitor and assess the products relating to construction on the market, to check that they are safe, that their kind of defectiveness wouldn't be able to result in an emergency or cause serious harm or death. And so they'll be checking the market constantly to make sure that all products used on buildings are up to standards. And they will also have the power to remove those products from the building as well, the market, that pose a safety risk to any building. So lots of new developments there in building safety. I think I'm just handing over to Alex now for looking at allergen labeling.
Thanks, Hannah. Yep. So following several high-profile fatalities and some serious incidents relating to the absence of allergen information on foods that are pre-packed for direct sale. We've got some new regulations which were introduced last October. So it's the Food Information Amendment Regulations, also known commonly in the media as Natasha's Law. So it's called Natasha's Law, effectively following the death of a young 15-year-old girl called Natasha Ednan Laperouse, who was in the airport about to go on holiday and went to a Pret to buy a sandwich, a baguette, and Natasha had a sesame seed allergy, and she picked up a baguette, and said baguette didn't have the said allergen, being the sesame seed, on the ingredients list, and she ate it and sadly suffered an allergic reaction and passed away. So effectively, that's the main sort of high-profile fatality that's been widely publicised throughout the news. Interestingly enough, before the regulations were announced or came into force, any sort of pre-packaged for direct sale food, which are foods that are presented to the consumer in packaging, quite obviously, packaged before the consumer selects and orders it, and then packaged at the same place that it's sold. So the common example is this sort of sandwiches. Before this regulation came into place, any sort of packaged food didn't require allergen labeling on its packaging, and could be provided by sort of any means, including verbally. So very, very lackluster. Effectively, what the regulations have done now is that any sort of PPDS food, as it's referred to on the slide there, must now display the name of the food, a full ingredients list, and should there be any allergens, and there's 14 allergens, couldn't name you all 14, they must be emphasized on the package. So whether you want to put it in bold, italics, as I said, they're a different color, it must be very, very, very clear on the packaging. And I think that the sort of the guidance here and our perspective from a legal point of view, effectively, if the regulations are likely to affect a business, you're definitely going to need to ensure that all your allergen procedures, labeling processes are updated following these regulations if you haven't already, to bring them into line with the new requirements. Failure to comply is a criminal offence, and which can lead to sort of significant fines, imprisonment for any culpable directors, in addition to personal injury claims as well, for failing to correctly label the PPDS, and then the obvious reputational impact on the business as well. And just a sort of bit of guidance, just sort of taken directly from the FSA, sort of Food Standards Agency website. A few things that they sort of advise doing of businesses. Very obvious: ensure that foods are correctly labelled. Ensure that there's sort of clear internal policies and procedures in order to comply with the regulations. Check regularly if there's significant risk of cross-contamination from the allergens within your kitchens. Pertinent to all of health and safety, but ensure that there's adequate training of staff. Carry out and also make sure it's put in a recordable format, appropriate due diligence of the supply chain. Check what contingency plans are in place too, should any of the ingredients change due to supply chain issues or new recipes that might come in place. And I think just the main one, again, pertinent to health and safety as a whole, is carry out regular reviews of the products and the policies as well. Make sure these done sort of very much on an annual basis. And next slide is something that is even more recently. It came into effect yesterday. So on the 6th of April, the new PPE at work regulations came into force, and effectively their purpose was to amend the 1992 regulations. So under the new regs, the 1992 regs aren't really changed, but are now more so extended to effectively include a new definition of worker. So it makes it a lot wider than was previously encompassed. So what it previously in the 1992 regs covered was a worker was effectively one that is under a contract of employment, and now it's a bit more casual. So it can affect someone who might just be on a sort of contract of service, for instance. Effectively, what the regulations note is that if PPE is required, employers must ensure that their Limb B workers, so workers that go beyond those who are under a contract of employment, have sufficient information, instruction and training on the use of PPE. It also affects the worker themselves in terms of their own obligations. They now have a duty to use the PPE in accordance with their training that they've been given by the employer, and ensure that it's always returned to the storage areas provided. And I think the main sort of takeaway point here is that, for employers who have both employees as such in terms of the definition and the Limb B workers, you effectively need to ensure that there's going to be no difference in the way that sort of PPE is provided and utilised by your workforce as a whole. And those employers with only Limb B workers, so those who don't fall into a contract of employment effectively, employers effectively need to ensure that those workers are provided with PPE free of charge, that it's maintained, correctly stored, and most importantly is used properly. Thank you.
Okay, so just turning to some recent case law now. I know case law can be a little bit dry, so we've tried to kind of pull out the interesting parts and summarise them for you. So hopefully it gives you kind of some helpful points that you can maybe take back to your businesses to help show them kind of the real life kind of impacts that these type of prosecutions can have. So starting with Severn Water that I know Alex has mentioned already. So again, yeah, this is an environmental case strictly, but because this case was also sentenced under the same sentencing guidelines that health and safety cases would be sentenced under, it is an interesting case to pull out the biggest fine that we've seen, so £90 million in fines for over 50 counts of discharging untreated sewage into coastal waters. So I'm sure you would have seen it in the news. Really serious case. Across a long period of time, across multiple different sites. And the reason why we've kind of picked this one out for this section is that the level of fine was 40% of the profits of the company for the previous year and seriously threatened the viability of the company. And I think this case shows judges' willingness when a case is serious enough to really use that power that they have to give unlimited fines, even where that could affect the viability of a company. So I think in that sense, it's an interesting one. It shows kind of the clout behind the sentencing guidelines, that it's still very much there. And the biggest fine we've seen since 2016, but it may not be the biggest we see going forward. Like Alex said, whether it kind of becomes a precedent remains to be seen. I think one of the reasons why they did set the fine at the level that they did is because it was considered to be a deliberate breaches. They're considered to have knowingly done that. So that's something to bear in mind. It's going to be reserved for the most serious of cases, but it just shows again, we're seeing the huge fines in this area, and the sentencing guidelines have got kind of a lot of power behind them in that sense. So then just turning to Cleveland Bridge UK Limited. So they were fined 1.5 million and costs of 29,000 after an electrician who was working at the site suffered fatal injuries following a fall from a crane. So really difficult case here, and I'm kind of pulling it out because obviously because of the high level of the fine, again showing the power of the sentencing guidelines in that respect. But it also highlights some of the risks around maintenance work. So what had happened is that on the crane there was a walkway and there was an access panel that was used for maintenance. I think they'd been maintaining some lights on the crane a few months prior, and the access panel wasn't put back properly, and it wasn't risk assessed in relation to the wear and tear on that access panel. So the access panel that is used for maintenance, which is obviously a positive thing from a health and safety perspective, kind of dealing with some other risks that arise out of the use of the crane, it was not thinking it through and thinking to that end point, okay, but what risks is the maintenance itself or the access panel for the maintenance itself actually posing, and how do we manage those? So that had been overlooked, which obviously resulted in a terrible accident and then a serious fine for the company as well. So that's just kind of the point around that, just thinking about risks holistically, and even when you're helping to solve one risk, it's thinking about what other risks might arise from that as well. So then turning to this Bupa case that you might have seen in the news as well, including costs, £1 million fine for Bupa. So this is in relation to fire safety that I know we've talked a lot about, but continues to be a real kind of a key topic and something of an enforcement trend that we are seeing. Even sometimes in some of the cases that we've worked on recently, there haven't been fires, but there have been risk-based prosecutions based on not having the correct kind of safety documentation. So we are seeing that kind of continue to be a real kind of enforcement trend. So this case related to a resident at a care home that unfortunately died in a fire while smoking outside at one of the care homes. So they're in this kind of smoking shelter, and the London Fire Brigade brought the prosecution against Bupa under the Regulatory Reform Fire Safety Order. So again, kind of a different regulator that we don't usually see. It's, you know, kind of different from the HSE, but one that can absolutely bring these type of prosecutions. And what happened here was the resident had been risk assessed as far as from a smoking perspective, like they knew that he smoked, but they hadn't properly kind of looked at the risk of the use of emollient creams on him and the buildup that could have on his skin and the extra fire risk posed by that. So I think that was something that was missed and overlooked, and unfortunately eventually contributed to this situation. So again, kind of similar to point to the last one, really looking at the risk holistically, making sure that you've considered everything from all angles in that sense as well. So then Mtl Advance Limited, so I've picked out this case because it relates to quite a common risk that we see quite a lot, especially in kind of manufacturing and metal fabrication companies like this one was. So hand-arm vibration syndrome, so using things like angle grinders and other machinery. It's a real risk from that perspective. And the HSE's investigation found that there were failings across kind of the board in failing to recognise the risk from hand-arm vibration syndrome and taking appropriate action. So I think that's one that for me, I kind of pull out to show that even if something's quite a common risk, quite a risk that we know a lot about, it's about keeping on top of that risk, you know, not kind of resting on your laurels in respect of that. And as you can see, the company was fined 90,000 in order to pay cost of 14,000. I actually looked up the company's turnover in this case to kind of get an idea of whether that was a significant fine or not. And in terms of the guidelines, given the turnover of the company was around 28 million, they could have been subject to a much higher fine. And obviously, I don't know the ins and outs of the case and the details of it, but I expect that they probably did have some good mitigation to put forward, and that maybe the culpability and harm levels were lower. But it's interesting just to, well, it's from our perspective, just to see how the courts decide to use those sentencing guidelines and where they pitch the different cases. But still a sizable amount of money. And then just finally from me, before I hand over to Alex, this is a case relating to a COVID-19 spot check, so something that we have seen more of in recent years. And this was the first prosecution arising out of those COVID spot checks. So it was a prosecution against an individual. So he was a principal contractor on the site, Mr. Katab. The HSE came to the site, did a check from a COVID perspective, but also found as well as COVID problems, lots of other problems in relation to working at height, electricity, so problems across the board, issued kind of a number of improvement notices, a prohibition notice, went back to check a month later after minimal kind of cooperation and communication from the principal contractor. The prohibition notice hadn't been complied with, so they issued a further one. The improvement notices hadn't been dealt with at all. So they kind of took the view that further enforcement action was necessary, so he was prosecuted, and so he sentenced to a community order of 12 months. So quite a long community order in that sense, and it just shows, I suppose, it's always kind of quite useful in these presentations to include some individual prosecutions as well. So it shows that it's not something that the HSE or other regulators are kind of shying away from. They where it's appropriate and where there's been kind of deliberate breaches and lack of cooperation, that they are willing to prosecute individuals as well. So it is a real risk, even though it can seem kind of, when it comes to health and safety, that it's a corporate problem, but there are cases increasingly with individuals being prosecuted. So just handing over to Alex now.
Yeah, absolutely. Thank you very much, Hannah. Interesting one, this. I'll just start with the fine. So it's a fine of £4 million. You think for a company like National Grid, that isn't a significant amount, plus £92,000 in costs. But effectively, it's for a failure to make available records for hundreds of properties. I think it was 769 properties, which effectively resulted in routine safety inspections not taking place. So background, effectively, just before I go on to why it's not a significant fine in terms of quantity, but in terms of the common misconception that it brings in. So effectively what happened is that HSE requested some information from various gas distribution network companies about how they manage their gas networks. And they found that when National Grid had sold part of its operations to Cadent Gas back in 2016, that records of these 769 buildings hadn't been transferred. And as a result of that, the buildings hadn't been, for a number of years, subjected to condition surveys, inspections, or even routine maintenance. And effectively what this means from a legal perspective is that from the perspective of the Health and Safety at Work Act, there's a duty on every employer to persons other than their employees, so the general public, to conduct their undertaking effectively in such a way as to ensure, so far as reasonably practical, as we discussed earlier, that these certain people, these individuals not in their employment, are not exposed to risks to their health and safety. So effectively, the HSE considered here that residents of the buildings, members of the public, were indeed exposed to a risk as a result of the incomplete records, which had directly effectively led to an absence of inspection. And the common misconception as what this highlights, which is just sort of the main point of why we've put this fine in here, what the significance of it, is that no injuries, no events, and no actual harm has to occur as a result of health and safety mistakes and breaches for criminal proceedings to take place. So an actual event doesn't need to happen. Someone doesn't need to die, someone needs to get injured, but something as significant as missing routine maintenance and inspections for years, as you can see there, can lead to a serious fine. And for a lot smaller company, that'd be a lot more difficult to manage. And just moving on to the next slide, which is a British Airways fines. This is a bit more recent. This is back in July 2021. Effectively, BA were fined £1.8 million following an employee who had sustained some very serious crush injuries, effectively. So the employee was struck by a tug pulling a tray of dollies. So dollies are the vehicles that are used to transport baggage around the airport. The employee effectively was knocked under another passing tug with dollies, and then that's how she effectively sustained the serious crush injuries. And the result effectively of the HSE's investigation found that the injured worker was using the centre of a roadway effectively between two lanes as a walking route, and this obviously very unsafe practice, especially at an airport, had actually been commonplace in said baggage hall for at least 10 years. And we've had a number of cases similar to that. I can think of one of a major retailer, their distribution centre, with a fatality a few years back in East London. Very similar sort of situation. Employees used certain walking routes and certain practices as commonplace, and there was no one there effectively to tell them. So it's sort of two main points of this really is that it's unsafe practice for a long time, and sort of transport risks, workplace transport risks, are very key indeed. And the investigation also very importantly identified failings in the general management of health and safety, and this included issues related to supervision, monitoring, overall risk assessment, and then one of the most important things, and that's training.
Okay, thanks, Alex. So just taking kind of the final section of our presentation and looking ahead now, and just thinking about a few horizon view topics that might be useful to discuss. So I think, as I kind of mentioned it at the top of the presentation, so thinking about how home working is really here to stay, and just making sure that the risks of the changing workplace are kept on top of, and keeping kind of ear to the ground, keeping on the pulse of that changing workplace. I think it has changed, it will continue to change, and yeah, home working is definitely here to stay. Kind of in the same vein, mental health and wellbeing will continue to be high on the agenda. I think we've seen that obviously throughout the pandemic, and even before, it was kind of a topic that had a lot of prevalence. So that's going to continue to be on the agenda, and as with home working, it's going to be a change, and the risks of that are going to change over time, and and it's about kind of keeping up to date with that and making sure that that's kept on top of, because I think it's going to continue to be a really important topic. I think it's probably fair to say that during the lockdowns, there was less enforcement activity, so less kind of proactive action from the HSE in that sense. And I'm sure if you're not seeing it already, probably will continue to see an increase in enforcement activity across your businesses, and kind of those proactive visits and unannounced visits. So something to be aware of. I mean, I'm sure it's probably something that's already kind of on your radars already. And then finally, just looking at kind of the use of technology in health and safety and opportunities to improve your processes, to kind of help automate maybe certain processes, whether that's kind of using VR or virtual reality for training, using wearable tech to help with risks to lone workers, using AI to deal with making sure people are wearing the correct PPE. So there's a lot of opportunity out there in terms of technology. But again, kind of as we've discussed with some of the cases that we looked at, it's about making sure that with the new stuff that you're bringing in that might be mitigating some risks, you're also thinking about the risks that they themselves pose. So keeping that holistic view on the risks there is one to bear in mind. So just passing over to Alex for our final slide, and then we'll deal with some questions.
Yeah, just some four top tips, I suppose, all very obvious to be perfectly honest with you, but sort of lead from the top, massively important one. Workers are definitely a lot more likely to get involved and comply with any controls you have in place if senior management make it clear themselves that health and safety effectively is being taken seriously by a business. This would include also, actively discouraging any negative behaviour such as risk taking, as you saw in the BA case, just to sort of save time or effort. Improve health and safety competence in your business. You can see there I've said sort of training 3 times. Make training regular. It's also important that in terms of that training, that evidence is always retained. And also evidence is obtained and retains that third parties on site, such as contractors, are properly trained and given sort of the health and safety lowdown. Also, it should include someone specific being appointed as a company's competent person for things like health and safety and fire safety too. Ideally, this should be someone with a sort of day-to-day involvement in the business, and that person themselves should be sort of provided with an enhanced level of training so that they can sort of fulfill that function appropriately themselves. Thirdly, risk assessment involvement. So get your workers involved in that risk assessment process. This will increase the overall buy-in and ownership ultimately of their own health and safety, for workers themselves. This might include setting up health and safety representatives, and if they're already established in business, we'll support them a little bit more visibly. And then finally, sort of implementing a health and safety management system for your business. This would include an overall policy, setting out your company's commitment, any responsibilities allocated to specific individuals, and then sort of arrangements detailing how the business will actually go about controlling said risks. And I think that's everything from us today, from a legal perspective. But if you've got any questions, we'd be happy to try to answer them.
Lovely, thank you very much. Over to you, Alison, now with the Q&A.
Okay, that's lovely. We've got a few questions that appeared in the chat. I'm going to read the first one out because we've got a question and also a response from one of the attendees here. So Mike Joyce asks, are you able to provide more detail on exactly what constitutes a LIMBY worker? So are independent contractors, temporary freelancers included? Mario, who's also on the meeting this evening, has suggested that a LIMBY worker can be defined as a dependent contractor, a worker who is registered as self-employed but provides a service as part of someone else's business. They generally must carry out the work themselves. So just looking to either of you for some clarification on that, please.
Yes, absolutely. I think what Mario said is right. And I think the LIMBY worker definition is quite wide. It covers kind of casual workers. So that idea of a temporary freelancer would be covered. And Alex, have you got anything to add on that? I think you took that slide, didn't you? So
the legislation is there to purposely make it a lot wider than it was previously. As I said previously, it tended to just cover individuals under a contract of employment. Now, Limb B, again, is still it's a bit vague, but it's a lot wider now. So it covers workers or those who are there to undertake work, effectively, who are under any contract. And that doesn't have to be a written contract. So it can be express contract, that can be implied, so oral or in writing. And under legislation as well, as Hanna said there, so it can be any workers who carry out casual or regular work, can be for multiple organisations as well. And I think, yeah, thank you, Mary. I think that pretty much covers it.
Can I ask an add-on question to that? Where would volunteers sit under that?
That is a good question.
My initial thought is that they would be included because I think it has made it particularly wide, but it might be something that we just need to double check if that's okay with you, and maybe we can drop you a quick email on it just to double check. Is that okay?
That'd be great.
Save us say something that we don't know, but I'm pretty sure it does include volunteers, but if it doesn't, I'm happy to be corrected. So I think, Alex, are you happy to follow up on that?
Yeah, we'll absolutely follow up on that one. Yeah, apologies. The legislation is so new, only came into force yesterday. So apologies on that we're not fully up to scratch with that one. But yeah, we'll get back to you on that.
That's super. We can always circulate any answers of things that you can, things we can't answer tonight. That's absolutely great. David Smith, are you still on the call? And if so, would you like to unmute and ask your question about the Cleveland Bridge case, or would you prefer I answered it for you?
Yeah, thank you. I was just curious actually, because the fine was huge, and I'm not sure when Cleveland Bridge went into receivership, but I was wondering, was that one of the factors that helped them on the way there, or if not, if they had gone into receivership, what had happened with the fine in that case?
Yeah, so it's an interesting question, and one that we don't come across that often, but it is, something that I am aware of. So with the Cleveland Bridge case, I'm not sure if it was before or after they went into receivership. I think they probably did go into receivership afterwards, but I'm not 100% sure. But with kind of who would be liable once the fine kind of, if it's not been paid by that time, they would just become kind of another creditor. The fine would just become another creditor to the company. So I'm not sure. It may be that it was paid, but in situations where the company goes into receivership, then or becomes insolvent, then they just become another creditor, which is obviously a difficult position, not ever an ideal position for those prosecuting, but sometimes one that's unavoidable. And I suppose it just links up. I mean, I'm not sure how directly the fine was linked to what then happened to the company, but it shows how these, the level of fines are really significant for a lot of businesses in terms of from a financial perspective.
Okay, thank you. Yeah, thank you.
You're welcome. Thank you.
Fantastic, Hannah. Mike Joyce has asked another question. He beat me to it because it was the question I wanted to ask as well. So, Mike, did you want to unmute and ask your question about the fire regulations? You're still up. We can't hear you, Mike, in case you're trying to unmute. Okay, seem to have a bit of a technical hitch, so I will read the question. Are there any provisions in the new fire regulations that relate to commercial and office buildings, or is it just multi-occupied residential buildings? There are high-rise buildings with several floors of residential flats located directly above offices, for example, the Cube in central Birmingham.
Alex, do you want to take that one from the fire safety, or?
I'm only aware that it covers domestic properties. I know that all businesses, all commercial properties under the FSO, which I know has been amended as a result of the Fire Safety Act, has to have a fire risk assessment as an absolute basic bare minimum. It has to be reviewed regularly, it has to be recorded by law as well, documented if said property requires a license. But in terms of the Fire Safety Act, which I know is the specific question, whether that covers commercial premises, I don't think so, but I don't want to give you an exact answer. Have you got anything to add on that, Hannah?
I think I'm the same as you, actually, Alex. I think it is interesting with these kind of multi-use buildings, like you say, with the kind of the offices and different types of use, whether it's shops and residential. And I think that particularly with the high rise, if there are residential flats, that it would be caught. I think it's to do with the height of the building, maybe not what everything in the building it is to do with. But if that's okay with you, and sorry that we can't provide the on the spot answer, but if it's something that we can follow up with you, Alison, I think that's probably best. Save us leading you down the wrong kind of lane, if that's all right.
No, that's fantastic. And again, we can always share the information.
Yeah, thank you for your question though.
That's great.
Good question.
Marliese, are you on the call, and would you like to ask your question? Because I think a little bit of context of the question might be useful.
Yes, good evening. I just wanted to know if there's any specific site or website out there that can give us more information on virtual reality training, wearable tech, and I'm not actually sure what AL means.
Oh, AI is like kind of artificial intelligence. So it's looking at, yeah. I'm sorry, yeah. Okay. Sorry, there's me just summarizing it. But it's an interesting one. I don't know of any specific companies. It's not something that kind of we deal with in our roles, looking at the specific companies. But the way I kind of found out about it was which might be kind of a good place to start, and kind of how I track it is mainly just online. It's kind of sources like SHP Online that I guess you guys might be familiar with, kind of do lots of webinars and podcasts talking about this type of information and this type of kind of tool and how it can be applied. So that's kind of how I stay up to date with stuff like that. So it might be worth, and sometimes they are sponsored by different companies, so it might be worth looking on there. So that's SHP Online if you don't know it already, but I'm sure some of you do. So that's kind of how I know about it and understand kind of the different benefits that it can bring. So hopefully that helps.
Fantastic. That SIP, what's that site?
Oh, SHP Online. It's like a health and safety website.
Yeah.
Fantastic. That brings us to the end of the questions that we've got in the chat. If anyone else has got a burning question, now is your moment. No, we're getting thank yous appearing in the.
Okay,
So,
lovely.
Thanks everyone.
And I think that's a good time to give the Midshires. I know it's virtually, but let's give a round of applause. What a fantastic presentation. Thank you.
Oh, thank you so much. Oh,
thanks all for listening. Really appreciate that.
No, absolutely brilliant. We can't thank you enough for your continued support. So it's nice to see.